May I please, Your Lordship?
Yes.
Lordship, I beg to mention hearing item number 45, Lordship. Lordship, if this can come up on 22nd May, Lordship.
In a second.
Yes, Lordship.
In a second. Just write down. In a second.
Much obliged.
Item 45.
Much obliged, Lordship.
PP is here. Short matter. Well, just. Yes.
Item 34.
May it please, Your Lordship. In item number 34 and 35, Your Lordship, there was an interim protection provided to us, Your Lordship. However, both the accused persons, they failed to appear before the investigating officer on 12th, Your Lordship. So may I pray for an extension, Your Lordship, and they may be provided an opportunity to appear before the investigating
Why
officer.
didn't they appear?
Am I audible?
Why didn't they appear on the date fixed by the
Your
court?
Lordship, I have been instructed that the informant had threatened the accused persons, Your Lordship. That is why they feared, Your Lordship. But unfortunately, they had not filed any complaint before the concerned police station, Your Lordship. I was informed only yesterday about it, Your Lordship. But we shall appear if Your Lordship kindly provides us
Fix another date then.
opportunity, Your Lordship. Yes, Your Lordship. And opportunity may be provided, Your Lordship.
Yes. Any objection?
Ladyship, I have
Yes.
objection because someone was already issued under 35 subsection 3 of BNSS. The accused, the petitioner in AB 15 has never appeared and non-able warrant of arrest has to be issued. And the police person had to go as far as Gauhati, Assam. Even that day, on sensing the arrival of police, it is reported he has escaped. And then even the applicant in AB 14, 2025, someone was issued. He has not been appearing. So they have not been cooperating with the investigation agency nor the order of this court. So I think
The petitioner is saying that he got some threats from the complainant.
they have to they have to bring it in the
let's
form of,
just give them one chance and then you keep this and update it and bring it on the next date, okay? This on 7/5/2025, this court had directed the petitioner to appear before the IO on 12/5/2025. Stop. And interim protection had been given to him till today. However, learned counsel for the petitioner, Mr. Deori, has submitted that he was not able to appear before the IO on 12/5/2025 due to some threats by the complainant. Stop. The interim, okay, when will we fix it? After a week?
maybe Thursday again. Yes, next week Thursday.
No, because he has to appear first, no?
Yes.
So let him appear on Monday, 19th, and then we'll fix the matter on 21st. No, Oh, 21st is Wednesday, 22nd. The petitioner shall appear before the IO on 19th May 2025, and the matter will be listed for hearing on 22nd May 2025. Stop. The public prosecutor
Very grateful.
and Ankami shall produce the updated case diary, and the interim order dated 7/5/2025 will continue till the next date.
My lady, if observation can be made, if the applicant does not appear on 19th, may the interim order be stands vacate automatically. If that can be.
Let's see. Both.
Very grateful, Your Lordship.
Item 38.
There will be 6.1. 6.2.
6.29.
Yes.
6.2.
Yes.
May I begin? The minutes of the DPC held on 10/3/23 simply state that as per the assessment of the APER and performance of the officers in the interview, the committee also on examination of all the available records of the officers in line for promotion had considered and recommended the following cases against the various categories of vacancies based on merit, seniority, and past performance of duties as below. In the grade of general manager, the respondent number 3 and the petitioner are shown as recommended for promotion, with the respondent number 3 placed as serial number 1 and the petitioner as serial number 2. Thereafter, a notification dated 15/3/23 was issued promoting the petitioner and the respondent number 3 to general manager. In a said notification, the petitioner is placed as serial number 2 and the respondent number 3 is as serial number 1. On inquiries, information was supplied to the petitioner that the minutes dated 10/3/23 and the notification dated 15/3/23 reflect the seniority between her and the respondent number 3. As such, the petitioner submitted a representation dated 17/4/23. Now, if you can go to the minutes of the DPC, leadership, and 26. Page number 110. Page number 110.
Lecture 26.
Yes, 26 at page number 110. Then page 111, minutes of the DPC. Then the members present. Then the chair of the meeting. And can we start from the second paragraph? Shri P. Sema, Managing Director NIDC and Member Secretary of the DPC apprised the members of all officers in line for promotion, which was placed before the committee against resultant vacancies. He further apprised the committee of the various vacancies at various levels of officer grade where the cases for promotion put up before the DPC consisted as below. So a whole number of posts. We are concerned with serial number 1.
General manager.
Yes, and you should see there are 2 posts. It is not as if the petitioner and the respondent number 3 were competing against 1 post. 2 posts. 2 posts. Rule number 29 of the NIDC service rules provides that the criteria for promotion for all category of posts, basic criteria for promotion will be merit, suitability, efficiency, and past performance with due consideration to seniority. The criteria to determine merit, suitability, and efficiency shall be on the basis of performance appraisals, interview or written tests, and also by assessing regular work. The appointing authority shall be competent to promote its employees through a DPC constituted by the board in case of officers and by MD in case of others. The committee members observed that the senior-most DGM, Shri Bendang Gap Rengma, did not turn up for the DPC. His absence for the DPC was viewed seriously by the committee members with a negative remark for his next promotion. So there were 3 persons actually who were present in line for promotion to GM, but 1 person failed to turn up. So that left only the petitioner and the respondent number 3. Thus, as per the assessment of the APAR and performance of the officers in the interview, the committee also on examination of all available records of the officers in line for promotion had considered and recommended the following cases against the various categories of vacancies based on merit, seniority, and past performance of duties as below. One, general manager, this is what we're concerned about, Your Ladyship. Two posts. One, Shri Timjin Younger, DGM, promoted to the post of GM against the vacancy of Shri Mianung Bao, retired. Two, Ms. Joy Sen, promoted to the post of GM against the vacancy of HPNU, retired. Very clear, we were appointed against two posts. And besides mentioning certain criteria which were taken into consideration, Your Ladyship will see there's nothing else in the minutes. It concludes at page 113. It deals with the other posts and nothing else. It contains no other material except showing that persons were appointed against, promoted against posts. But the most important point of note, Your Ladyship, two posts.
Yes, two posts.
Yes. So there's no question of supersession here. Two persons were considered independently against two posts. Where was the necessity of assessing comparative merit also, Your Ladyship? Absolutely not necessary. And this was followed by the notification, which is at annexure 27, next page, page 114. In pursuance to the decision of the DPC held on March 10th, 2023, the management in the interest of the corporation is pleased to accord officially promotion to the following officers of Nagaland Industrial Development Corporation as per details listed below. Even the language is a little mixed up, Your Ladyship, but A from Deputy General Manager to General Manager. One, Timjin Younger Jami, Mayor Nungba Ao, retired. Effective date of promotion, 10th March 2023. Ms. Joy Sen, that is the petitioner, 10th March 2023. So the point of note, Your Ladyship, is that the DPC decided that both of them will be, the effective date of promotion of both of them will be 10th March 2023. No different dates. This is also important, Your Ladyship. 10th March 2023. And again, can we revert back to the petition? So I submitted a representation, which is annexure 28, not necessary to go into that petition, at paragraph 7 now. That ignoring the representations of the petitioner, an office circular dated 21/4/23 was circulated containing the seniority list of the employees of the NIDC. In this list,
in the grade of his.
yes. In this list, in the grade of general manager, the name of the petitioner of the respondent number 3 is at serial number 2, ahead of the petitioner who is at serial number 3. The petitioner submitted another representation dated 2/5/23. To all effects and purposes, the representation submitted by the petitioner have been rejected. So the seniority list may not be necessary to go to the seniority list. I've mentioned the serial numbers. Then paragraph 8, that the rules prescribe that the inter-se seniority of the persons promoted from the lower grade shall be maintained in the higher grade. We were going through the rules earlier, Your Ladyship.
Yes.
In this regard, rules 28 and 29 of the rules may be produced. Further, even in the lower grade, the feeder post, the petitioner and the respondent were both promoted to deputy general manager on the same date. Resorting to the same modus operandi in the present case, he has been placed above the petitioner in the seniority list. Rules 28 and 29 are reproduced here on there. So no need to go into the rules again, Your Ladyship. Paragraph 9 now. That the minutes of the proceedings of the DPC dwell on merit cum seniority and past performance of duties for promotion. The petitioner and the respondent were appointed to two different posts. Therefore, the question of assessing relative merit did not arise. A case of a similar nature occurred in the year 2005, where two officers in the grade of DGM were promoted to GM. Unlike the proceedings in relation to the petitioner and the respondent number 3, the DPC at that point of time adopted an elaborate mechanism to assess merit. In its meeting held on 23/9/23, the DPC assessed a junior officer as being more meritorious. Based on the recommendation of the DPC, by order dated 24/10/2023, the junior officer was placed above his senior. So the records are here at annexures 31 and 32.
The earlier.
Yes,
earlier
the earlier case. It is all there in black and white. My ladies, it may not be necessary to save time. I will not take your leadership to that. At 9.1 now. The NIDC in its meeting held on 31/5/25 observed that the role of the DPC was to assess and recommend eligible candidates for promotion and not to determine seniority. Consequently, instructions were issued and the management was directed to issue necessary orders rectifying the earlier defective order. Resultantly, by order dated 4/7/25, the placement of the junior officer ahead of his senior in order of merit was rectified. A similar case occurred, and this is what happened earlier. And this is the practice which the NIDC follows. Then the records are there again, your leadership. I have not taken leadership to those records. Everything is there. And paragraph 10, that by their actions, the NIDC has rejected the representations submitted by the petitioner. The records show that the NIDC has decided that respondent number 3 should rank above the petitioner in the grade of general manager. In Rule 11, paragraph 11, this talks about the manner in which the person has been regularized. That according to the rules, there are only 3 modes of appointment: direct recruitment, promotion, and deputation. The respondent number 3 was not appointed through the above referred prescribed modes of appointment. As earlier stated, the service of the respondent number 3 was regularized by order dated 23/3/2010. Regularization of service is alien to the rules and therefore illegal. In paragraph 12, this is important, Your Lordship, Your Ladyship, that the petitioner had no cause to be aggrieved by the regularization of the respondent number 3's service. The illegality in relation to his service continued when, through a process ultra vires the Constitution and rules, the respondent number 3 was directly appointed to the post of Deputy Manager by the Departmental Promotion Committee. The Departmental Promotion Committee is not empowered to make recommendations for direct appointment. In his initial appointment and subsequent promotions, the petitioner had no reason to be aggrieved. The earlier attempt to place him senior in the grade of DGM was rectified by the NIDC, which we referred to earlier, Your Ladyship. 13, that in the instant petition, the petitioner has challenged the service of the respondent number 3 from the very inception as she now stands aggrieved. Now, why am I making this point, Your Ladyship? Ground has been taken that delay, lashes, etc., etc. But I had no reason to be aggrieved until this seniority list came out. As someone who was appointed the constitutional provisions and the rules, respondent number 3 is enjoying unjust and illegal gain. This undue advantage of the respondent number 3 is now sought to be translated into him being placed above the petitioner in the grade of general manager. 14, that the orders dated 23/3/10 and 16/8/12 are the basis of the respondent number 3's entry into service. His direct appointment by the DPC shows that his status as a departmental candidate. Therefore, when the initial order, foundational order, is bad in law, all subsequent actions, orders based on the same are also bad in law. As such, the orders issued by the NIDC in relation to the service of the petitioner of the respondent number 3 are liable to be quashed and set aside. Now, if I may take your leadership, these are basically the facts. Take your leadership to what I am impugning in my petition. Your leadership will come to my prayers. At page 28. The facts are more or less covered in leadership. At page 28, the first quash and set aside, order dated 23/3/10, regularizing the service of the respondent number 3 as assistant manager. That is election 9. Can we go to election 9, your leadership, which is at page 46. The type copy, yes, it's page 46.
Election 9.
Yes, election 9 at page 46. In the interest of the corporation, the ad hoc service of Shri Timjan Younger Jamir is hereby regularized to the post of assistant manager with effect from 24th February 2010. The date is important, your leadership, 24/2/2010, in the scale P of such and such, plus all other allowances as are admissible from time to time, and his seniority shall count from the date of regularization. So his seniority in this grade will count from 24/2/2010. Shri Timjan Younger Jamir will be on probation for a period of 1 year, which is extendable subject to performance of the employee, and service confirmation shall be further subject to satisfactory performance of the employee. He shall be entitled to join CPF and other related schemes of the corporation on completion of 1 year from the date of regularization. So by virtue of this order also, he was on probation and his service was subject to confirmation. Then the next document which I have challenged and the order which I have challenged is at annexure 35, page 134. Page 134. 134. 134. This is the meeting of the board of directors. So the argument was taken that I had not challenged the basic order,
Mhm.
and which is the minutes of the board of directors. So I had to amend my petition and bring this on record. But ultimately, as the leadership will appreciate, the minutes of the board of directors translated to the orders which have passed. There was no necessity, but just as a matter of abundant caution, I did it. And this is resolution 188 by 185,
185th meeting.
page 143. Page 143. Resolution number 185-8.
Page 143. Yes, 185/8.
Yes, 185/8, 143. So this is the order promoting him by the DPC, appointing him directly by the DPC. 143. May I read?
Yes, let's see.
The board noted that consequent to the and one more thing, Your Ladyship, the argument of the state which I was referring to earlier, the alternative remedy, an appeal to the board. This is a decision by the board. So for me to appeal from a decision of the board to the board, that is absolutely irrational. The board noted that consequent to the promotion of Shri I. Jamir and Shri Nohota Shoaib as MD and ED respectively, the resultant vacancies which have risen at various levels required to be filled up through promotion, appointment of eligible officers in the corporation. My lord, your leadership may even look at the heading, recommendation of DPC. And this is again a reference to DPC. The board noted that the DPC constituted for the purpose has taken into consideration all aspects like qualification, experience, merit, service records, ACRs, as well as seniority, and have also conducted written tests and oral interviews wherever it felt necessary, and has recommended the following officers to be promoted to the post mentioned against their name as follows. Serial number 5. Lordship will see. Leadership at serial number 5. Shri Timjin Younger Jamir, Assistant Manager, to the post of Deputy Manager. To the post of Deputy Manager. And this is the minutes of the board in its 185th meeting held on 13/8/2012. Your Lordship will get that date at page 134. Page 134. Held on August 13, 2012. Has the leadership got that?
Yes.
So by these minutes, your leadership, the board approved the decision of the DPC to directly recruit respondent number 3 to the post of deputy manager. And this was followed by Annexure 10 at page 47. May I read, Your Ladyship?
Yes.
Page 47. In the interest of the corporation, as approved by the Board of Directors in its 185th meeting held on August 13, 2012, the management is pleased to appoint Shri T. Jamir to the post of Deputy Manager against existing vacancy in the pay band of such and such, plus all other allowances as are admissible under the rules in force from time to time with effect from the date of assuming charge. So again, Board of Directors. No confusion now in leadership about the approval having been done by the Board of Directors. And one more thing your leadership will notice, this is 2012. There was no management cadre at 2012. There was no such thing as a management cadre. There was just one single cadre. That is the cadre of officers serving in the NIDC. Because the ground has been taken that I have no locus standard to challenge this because the respondent number 3 was appointed in the management cadre. By saying that in the affidavit, again, the leadership has settled principle of law. By saying that, can they improve the case? Can they improve what is mentioned in the order by way of an affidavit? That is the point. This is very clear. There is no management cadre. Just someone appointed to service in the NIDC. Then, next one is Annexure 5 at page 42. So since I have to challenge all his orders, your leadership, that's why I have challenged all the orders. This is dated 19 June 2017. Consequent to recommendation of the DPC and subsequent approval of the Board of Directors by decision dated 15 June 2017, the management is pleased to order officially promotion of the following deputy general managers to the post of manager in the pay band of such and such, plus all allowances admissible, etc., etc. The name of the respondent number 3 is serial number 1, and I am a serial number 4. Now, again, very interesting point of note here, Your Lordship. 1, 2, 3, 4. I am a serial number 4.
Yes.
But no dispute that I am senior to him.
Mm.
In the seniority list, there is no dispute. In the recent DPC, for the very first time, on the basis of serial number 1 or 2, he just decided that this one number 3 is senior. Next is annexure 11 at page 48. May I read?
Yes,
This is
yes.
dated 4th September 2012. No, annexure 11. Annexure 11 is the page
Page 48.
48. Official promotion letter.
Mm.
In pursuance to the decision of the DPC held on August 17, 2020, the management in the interest of the corporation is pleased to accord official promotion to Sri T. Yami, manager to the post of DGM in the pay scale of such and such. Now, before this, the other letter at annexure 10A, this is also very interesting, leadership. Subsequent to the direct appointment, so it is very clear it is direct appointment.
Direct appointment. Yes.
Direct appointment of Sri T. Younger, assistant manager to the post of deputy manager as a departmental candidate. Look at that, Your Leadership, very clear now. And pursuant to the Government of Nagaland PNR reforms memorandum dated 1st August 2012, the service rendered by him as assistant manager with effect from 7 February 2017 till 15 August 2012 shall be counted for computation of public employment under the Nagaland Retirement from Public Employments Act 2009 and included in calculation of length of service. Why is this interesting, Your Leadership? Direct recruitment. Direct recruitment means he must have resigned from his earlier post. He must have resigned from his earlier post. But he did not resign. And his past service has been counted for computation of his length of service for the purpose of pension, etc. Then, annexure 26 at page 110. And this is the minutes
This is
of the
another DPC.
Yes, of the DPC held on 10th March 2023. This is the one we were referring to earlier, Your Leadership.
Yes.
Then next is annexure 12, page 49. Page 49. Officially promotion letter. In pursuance of the decision of the DPC held on 10 March 23, the names in the interest of the corporation is pleased to accord officially promotion to T. Jamir to the post of general manager. So this is the promotion to the post of general manager and the promotion by which he was placed senior to me. And sure. 27. Annexure 27 is next. Leadership, page 114. Page 114. And this is the notification which followed the minutes of the DPC, which we referred to earlier, Your Leadership. Annexure 27, page 114. Yes, Your Leadership, got it.
Yes.
And next is annexure 29, page 118. And this is the seniority list pursuant to the minutes, the meetings of the DPC and the orders. This is dated 21st April 2023. And If your leadership will turn to page,
This is the one where your junior.
yes, page 119. Page 119. In group A, the first group, the respondent number 3 is at serial number 2, and I'm at serial number 3. And prayer B, your leadership is for rectification of the seniority list. A prayer for the rectification of the seniority list. At page 30. Now, what does the state say? The affidavit of the respondents 1 and 2. Has the leadership got it? 1 and 2. And beginning from page 2. Beginning from page 2. And the state and the NIDC, they have filed a joint affidavit, and they have taken objection to maintainability of the petition, non-exhaustion of alternative remedy. Has your worship seen that?
Yes.
Paragraph 2. As per the extant service rules of the NIDC, Rule 4 provides that employees a right of appeal to the Board of Directors as regards the interpretation of rules or any of the provision of the rules. And I was submitting earlier, your leadership, this is an argument which does not deserve the consideration of the sovereign court. Then in the same breath, in paragraph 4, in the same breath in paragraph 4, conversely, the petitioner at paragraph 9 and 9.1 of the petition relies on some past actions of the NIDC pertaining to correction of inter-state seniority dispute between two other employees. Notwithstanding the relevancy of such past actions in this present petition, it may be noted that the correction to the inter-state seniority therein was done by the BOD in exercise of its powers under Rule 4. In this regard, the deponent has made necessary affirmance regarding the aforestated BOD decisions, and the appropriate paragraph of this affidavit will be herein below. So they admit that inter-state correction is done by the Board of Directors. Then paragraph 5 is again on maintainability without exhausting the alternative remedies. Has your leadership got that?
Yes.
Then paragraph 7 now begins dealing with the affirmance in the paragraph, in the writ petition. 7, 8, 9, general statements. 10. Can we come to paragraph 10, your leadership?
Paragraph 10.
Yes. That is regards paragraph 3. The deponent states that the service rules of the NIDC is non-statutory, which has been framed by the BOD to regulate the conditions of service of its employees. The organizational structure of the employees of the NIDC has undergone certain changes over the course of the years since its inception, which has been narrated here and below at the appropriate paragraphs. Ultimately, the BOD in its 194th meeting on 15/6/27 made further changes to the sanction strength, promotional channel, education, qualification, and minimum length of service for further promotion pursuant thereof. The notification dated 22/6/2017 was issued incorporating necessary changes, thereby superseding all previous decisions. The same forms part of the service rules as annexed herein. So therefore, the leadership, the submission that I was making prior to this notification dated 22/6/2017, there was no cadres, there was no classification admitted. And the records also show that it is admitted, of course. So the respondents 1 and 2, they also aver that by virtue of this notification dated 22/6/2017, the classification, the so-called classification, which they are harping on now, came into existence. So prior to 2017, there was no classification. And the petitioner, as well as the respondent number 3, were appointed at a time when there was no classification. That is now abundantly clear. Then paragraph 11 is about the reorganization after the notification dated 2017. And paragraph 12, can we come to paragraph 12, Your Ladyship? When the service rules for the NIDC was first framed in 1991, a separate cadre for legal section service was not envisaged. This can be observed from a perusal of the old annexure channel of promotion of the service rule. In fact, there was no legal service cadre then except for the existence of a post. A brief account of how the board, so they are now saying that in terms of the rules of 1991, there was no separate cadre for legal. But the fact of the matter was a post was created and people were appointed under the rules. Assistant manager legal. Then 13.1. In the 64th BOD meeting at resolution 5B dated 18/12/29, the board sanctioned and created a post of assistant legal officer, perfectly within the purview of the board of directors in terms of the rules. The post was redesignated as assistant legal manager by the board in its 89th BOD meeting dated 26/8/1983 by resolution 3.5 clause 9. Thereafter, the board in its 118th meeting dated 28/3/90 at resolution 6 created a new post of manager legal, and then the then incumbent serving as assistant legal manager was promoted to the newly created post. The post of assistant legal manager was consequently abolished. Thereafter, the service rules of 1999 was framed by the board, but as aforestated, the post of manager legal did not find a place in the service cadre. Consequently, the above said post of manager legal fell vacant somewhere in 1992 due to the expiry of the incumbent officer. To replace the same, one Shri K. Nakro was engaged as legal officer on retainer basis, right letter dated 22/12/92. 13.2. Thereafter, the board in its 138th meeting dated 9/7/93 by resolution number 7 regularized the services of K. Nakro as legal officer, pursuant to which letter of appointment was issued on 12/8/93. Consequently, by the same resolution, the board in its wisdom abolished the then existing post of manager legal. 13.3. Pursuant thereto, the board in its 144th meeting dated 24/4/97 by resolution 144/13 approved the redesignation of the existing post of a staff officer to assistant manager and that of assistant manager to deputy manager. Next, thereafter, in accordance with the BOD resolution 144/13, an office order dated 12/6/98 was issued redesignating the post of legal officer as deputy manager legal. 113.5. Inter alia, the board in its 151st meeting dated 28/7/99 by resolution 151/13 acknowledged the then legal section of the NIDC was not performing satisfactorily. Having considered the prevailing situation, the BOD approved and created a post of assistant manager legal. 13.6. Pursuant to the aforesaid decision of the BOD, the petitioner was appointed as assistant manager by order dated 8/10/1989. Thereafter, the board in its 154th meeting dated 6/5/2000 constituted a committee of directors to study the NIDC service rules with particular reference to the promotional channel and scope of infusion of fresh blood into the workforce of the corporation. The recommendation of the said committee was submitted consequently, which was approved by the board in its 157th meeting dated 24/7/2001 by resolution 157/16. In this regard, it should be pertinent relevant to for this honorable court to note the following approvals of the board amongst others. So whole series of decisions are quoted here. Then paragraph 15, which is a misleading statement. By letter number dated 24/7/2002, the petitioner's service was thereafter regularized in the post of assistant manager legal. Now, it is made to appear as if I was also serving on an ad hoc basis and subsequently regularized. No. Initially, yes, ad hoc, but I went through the selection process by the selection committee. My probation period was completed. Upon completion of my probation period, my service was regularized. That is the full import, and your worship will see that at page 140 of this affidavit. Page 140. At first glance, the statements would be very misleading in relation. A typed copy is at page 141. On successful completion of probation period from 13/6/2001 to 12/6/2002, the management is pleased to regularize the services of Ms. Joyce and assistant manager with effect from such and such. So It is not the regularization of someone who was in ad hoc service. It is the regularization of someone who completed her probation. Then 16, the respondent number 3 was consequently appointed to the post of assistant manager on temporary basis, by letter dated 1/4/25. The appointment was made in the quota of the management service cadre. A deliberately false statement. Deliberately false statement. Just to favor the respondent number 3. 2017 notification created the so-called different cadres. Before even the cadre was created, the respondents 1 and 2 are saying that respondent number 3 was appointed in the management cadre. The BOD in its 177 meeting dated 10/6/2008, inter alia took 2 decisions pertaining to the petitioner and respondent number 3, both independent of each other. So 17.1, by resolution 177/8, the board noted that there were 10 employees, including the respondent number 3, who were serving the corporation on ad hoc temporary basis. As such, in accordance with the principle contained in the then standing OM of the state government for regularization of employees who have completed 3 years of service on sanctioned posts, the BOD constituted a committee to assess the suitability of the incumbents. Now, then 17.2, concurrently, the BOD by resolution 177/11 considered the representation of the petitioner for promotion to the next higher post of deputy manager legal. The BOD decided that such promotion would be considered only after restructuring of the corporation. If we can go to the minutes of the BOD, which is at page 143. Resolution 177/8 and 177/11. 177/8 is at page 144. The board noted that presently there are 2 assistant managers, 5 grade 3 staff, and 3 grade 4 staff on ad hoc temporary basis, among whom some have completed on or are almost going to complete 3 years of continuous service. The board further noted that the BOD in its 174th meeting held on February 27, 2007, held that the NIDC, being a government company, should also follow the state government norms of considering regularization after 5 years of service. Now, pertinently, Your Lordship will notice, this meeting is on 10 June 2008.
10 June 2008.
143, yes. Then the board, taking into consideration the state government had reduced the minimum length of service to 3 years of continuous service to be eligible for regularization against sanctioned posts, decided to constitute a committee to assess the suitability of the candidates of the incumbents as follows, such and such, a committee. Then 177/11. At page 146. The board noted that a representation has been submitted by Ms. Joy Sen, assistant manager, requesting for promotion to the next higher post, deputy manager in the legal service cadre. The board maintained that its views as an item number 177/10 would also apply to the present case also. So this is what they are saying about my service. But the fact of the matter is, Your Leadership, this meeting is 10th June 2018. 2008. One ground that I am taking, Your Leadership, is that whether it is the state or its instrumentalities, after the decision of the Honorable Supreme Court in the case of Uma Devi, such kind of resolutions could not have been adopted. Such kind of decisions could not have been arrived at. And Uma Devi is 2006, Your Leadership.
2006, yes.
2006. Then at paragraph 18 now, Leadership, of this affidavit, paragraph 18. For the purpose of regularizing the services of the respondent number 3, the respondent number 2, by letter dated 14/9/2009, wrote to the Director of Industries and Commerce, Kohima, for fixing a date for suitability test. The regularization of the service of the respondent number 3 was to be carried out in accordance with the principles laid down in OM dated 4/8/2008. And Your Leadership is familiar with this OM. Earlier OM saying 3 years of continuous service, you'll be entitled to be regularized. Then paragraph 19. Pursuant thereof, the committee in its meeting held on 24/2/2010 recommended the regularization of the respondent number 3 along with another employee to the post of assistant manager. Accordingly, by an appointment order dated 23/3/2010, the services of the respondent number 3 was regularized. There we have it in black and white. He was not appointed through any selection process. He was regularized in service. Yes. At this instant, the Honorable Court may note that the regularization of respondent number 3 has been done in the quota for the management service cadre. Again, look at the blatant falsehoods that the respondents want to do are indulging in leadership. There was no such management cadre in 2010. And not in the quota for the legal service cadre. It may also be noted that the petitioner does not possess the educational qualification prescribed for the post of assistant manager under the management service cadre. Therefore, it is respectfully submitted that the petitioner has no locus standi to assail the regularization of the respondent number 3. And this is again a falsehood. Lordship will also require, in certain circumstances, just a graduate degree alone will be sufficient. We were referring to the rules earlier. Yes. In paragraph 20, in its 182nd meeting dated 24/2011, the board by resolution 187 noted that there were a number of officers and staff in the corporation who have remained stagnant in a particular post without any further ascension in service. To overhaul this, the BOD approved and constituted a career review committee for its officers, while an in-house career review committee for the staffs was to be constituted by the respondent number 2. 21, while the matter was situated as such, the respondent number 3 submitted an application dated nil, seeking to apply for the post of deputy manager. This is where we come to the post of deputy manager, and this is the statements of 1 and 2. For the post of deputy manager as a fresh candidate. The application was considered and the respondent number 3 was directed to attend the DPC. Admission of facts now, Your Ladyship. Meeting by circular dated 17/7/2012. Then 22. The DPC thereafter sat on 26/7/2012 for consideration of the matter. They don't deny it. At clause 4 of the meeting minutes, the DPC considered the case of the respondent number 3. After having considered the performance of respondent number 3 in the written and oral test coupled with the ACRs, the DPC recommended his appointment as an in-service candidate to the post of deputy manager under the direct recruit quota. So if you can go to this DPC minutes, Your Ladyship, this is at election 23 at page 160. Page 160. At page 160, this is issue 23. May I read? Minutes of the meeting of the DPC constituted for consideration of promotion. Look at the heading also, Your Ladyship. Considered for consideration of promotion to the officers of NIDC held on July 26, 2012 at NIDC office Dimapur. The DPC held its second meeting to examine service records, ACRs, and conduct interviews wherever required for the various levels of officers in NIDC, and after thorough deliberations recommended as follows. GM were not considered with that. DGM were not considered with that. Post of manager were not concerned with that. Post of deputy manager. May I read this, Your Ladyship? The committee noted that for the post of deputy manager, the ratio of appointment by direct recruitment and promotion was 50:50. The committee was apprised that presently out of the existing 5 posts of deputy managers, only 1 is being held by a direct appointee and the remaining 4 posts by promotion. The committee was apprised that on the basis of a representation submitted by Shri Timjan Yangar Jamir, respondent number 3, assistant manager, to allow him to appear for the written test and interview as he possessed the necessary qualification and work experience, the management had allowed him as an in-service candidate despite not having completed the minimum years of service to be eligible for promotion to the post of deputy manager. Look at the way in which he has been favored. Relax the years, at the same time, the promotion, the DPC is appointing someone on a direct basis or by direct recruitment. The committee noted that as in the case of manager NIDC, had conducted a written test of eligible officers for the post of deputy manager. The committee noted that 3 officers who were eligible for promotion and 1 officer as an in-service candidate having the requisite qualification for direct recruitment have undertaken the written test. The committee thereafter conducted oral interview of the officers and assessed them on the basis of the following criteria: aptitude, personality, knowledge, and experience. The committee gave markings on a scale of 10 for each of the above criteria. The committee further added that grading scored in the ACRs of each of the officers and the marks secured in the written test. Recommendation: on the basis of the marks secured in the written test, oral interview, and ACR grading, the committee recommends the appointment of Shri Timjan Yangar Jamir to the post of deputy manager as an in-service candidate to be taken as direct recruitment. Look at that, Your Ladyship. And what does this minutes also say? The committee thereafter conducted oral interview of the officers. Only oral interview was conducted. There was no written exam. It mentions a lot about assessment of ACRs, APRs, written statement, but what does it say? The committee thereafter conducted oral interview of the officers and assessed them on the basis of following criteria: aptitude, personality, knowledge, experience. The committee gave them markings on a scale of 10 for each of the above criteria. And the recommendation that he is recommended for appointed as an in-service candidate and to be taken as direct appointment. Then 22.1. Concurrently, the DPC at clause 5 of its meeting minute considered the case of the petitioner. The committee observed that the petitioner has been looking after the legal department of the NIDC following the deputation of the manager to NPSC. The DPC also noted that the petitioner has been in the same position for over 11 years. Having found so, the DPC recommended the upgradation of the post of assistant manager legal to that of deputy manager legal and to accord promotion to the petitioner to the upgraded post. So clause 5. Can we come to clause 5 at page 161?
Yes.
Post of deputy manager legal. The committee noted that Ms. Joyce, an assistant manager legal, has been looking after the legal department of the corporation single-handedly following the deputation of the manager to the NPSC. The committee further noted that Ms. Joyce, having an LLB degree, has been competently discharging the duties and has been in the same position for over 11 years. And as such, if found suitable by the DPC, the management proposed to upgrade the post of assistant manager legal to deputy manager legal, and the incumbent be promoted to the upgraded post. The committee noted that there was no adverse remarks in the incumbent service record, and the ACRs have been highly graded. Recommendation, next page at 112. Taking all the above into consideration, the DPC recommend the upgradation of the post of assistant manager to that of deputy manager legal and promoting Ms. Joyce to the upgraded post, which shall be personal to the incumbent. So this is fully within the competence of the DPC, Your Ladyship. There can be no argument against this. The DPC does not recommend that I be directly appointed to the post of manager. The DPC recommends that the post be upgraded and that I be considered for promotion against that post. Then at page 18 now, Your Ladyship, paragraph 33. The BOD thereafter held its 185th meeting on 13/8/12. By resolution 185/8, the BOD examined the recommendations of the aforesaid DPC and approved the said recommendations pertaining to the respondent number 3 and the petitioner, amongst others. The promotion of the petitioner to the post of deputy manager legal was made personal to her. Now, if you may pause here for a moment, Your Ladyship, it is a settled point of law. The recommendations, the decisions of the DPC are recommendatory in nature. It is up to the employer to accept or reject. In my case, I am saying it is proper to upgrade the post, single post to manager. It is proper. It is fully within the competence of the DPC. In the respondent number 3's case, the DPC has no competence to recommend direct recruitment, because the argument is being advanced by both sides on the other side that I cannot accept some and reject some, approbate and reprobate. And paragraph 24. Accordingly, by 2 separate orders dated 16/8/12, the petitioner was promoted to the post of deputy manager, and the respondent number 3 was appointed to the post of deputy manager with effect from the date of assuming charge. In this also, this honorable court may note that the appointment of respondent number 3 to the post of deputy manager is in the cadre of management service, in which the petitioner has no educational qualifications and therefore lack the locus to raise any grievance thereof. Where, Your Ladyship, there is no management cadre. Again, a blatant falsehood. Then 25. After several sittings, the recommendations of the cadre review committee constituted by the BOD's 182nd meeting was eventually submitted. The BOD in its meeting dated 15/6/2017 by resolution 194/5 considered, examined and approved the recommendations of the Cadre Review Committee with necessary changes. The BOD by Resolution 194/6 also approved the recommendations of the DPC inter alia. The petitioner and the respondent number 3 were approved for promotion to the post of manager legal and manager respectively. Now, this is the minutes, notification of 2017 by which the so-called classification was introduced. 15/6/2017. The leadership will recall. Yes. So prior to this 15/6/2017, there was no management cadre. In paragraph 26, is after the approval of the minutes of the DPC. 26 is the orders by which the petitioner and the respondent number 3 were appointed to managers. And paragraph 27, the notification dated 22/6/2017 was also issued incorporating the changes in the service rules approved by the BOD in its 194th meeting. The changes have been incorporated in the form of annexures. The 4 categories of changes superseded all earlier decisions and holds the field as of today. So I have no arguments with this. Prior to 2017, there was no classification. After 2017, the classification came in, but the classification stopped in the converged in a grade of DGM, as your leadership has already seen. Then 28, paragraph 28. For considering further promotions, the DPC sat on 17/8/2020. After perusing all the available records of the officers in line for promotion, inter alia recommendations were made for according promotion to the petitioner and respondent number 3, along with another manager to 3 vacant posts of DGM. In a select list as recommended by the DPC, the respondent number 3 was placed as serial number 1 and the petitioner number 2 at serial number 2 in accordance with the principle of seniority cum merit. Accordingly, separate promotion orders were issued. So this is the earlier seniority list which was rectified, which I was referring to earlier, Your Leadership.
Yes.
29, in view of further vacancies being created in the higher posts, the DPC sat again on 10/3/2023. Now, this here the state has not dwelt on the other seniority list. I mean, my representation is the correction of the seniority list, but that is there in my petition. The leadership will recall.
Yes.
And now the state has proceeded directly to the latest DPC. In view of further vacancies being created in the higher posts, the DPC sat again on 10/3/23. Inter alia, the DPC recommended the promotion of the petitioner and the respondent number 3 to the post of general manager. In the select list, the respondent number 3 was placed above the petitioner in accordance with the principle of merit cum seniority under Rule 29 of the service rules after assessing their APR performance in interview and examining all the available records, including the past performance of their duties. Accordingly, notification dated 15/3/23 was issued according officiating promotion. Then the DPC minutes, which we have already referred to, Your Leadership. Paragraph 30, the BOD thereafter sat for its 198 meeting on 31/3/23, and by resolution 198/4, the board approved the recommendations of the DPC held on 17/8/2020 and 10/3/2023. 31, in the light of the facts and circumstances narrated supra, the opponent admits the statements made in paragraph such and such insofar as they are borne out by the records as produced here and above. So basically, this is the stand of the state. There is an alternative remedy that has not been exhausted. The respondent number 3 has been appointed in the management cadre. And so I have no locus standi. Now, one telling factor, Your Leadership, which negates these 2 points. Firstly, decision by the Board of Directors. There's no question of filing an appeal against the Board of Directors to the Board of Directors. Secondly, in all the seniority lists, I am placed senior, except for the yes. So where is the question of saying he is in the management cadre, I am in a different cadre, therefore I have no locus standi. If we were in different cadres, where is the question of maintaining a same seniority list, Your Leadership? All along, it is one single seniority list. The seniority list has not been published or has not been maintained in terms of different cadres. Just one single seniority list. Even in this impugned seniority list, there is just one seniority list. There is no seniority list based on cadres. And also, Your Ladyship, this so-called classification, apart from the fact that it has no meaning as far as the service between the respondent number 3 and the petitioner is concerned, it ends in the grade of DGM. This so-called classification.
Yes, yes.
It ends, yes. So to raise the issue of saying different cadres, that is again, by virtue of this convergence, a self-defeating argument. So from DGM to GM to MD, same channel of promotion. So the respondents 1 and 2, they are, I find it very difficult to understand why the state must be fair, Your Ladyship. Why the state can come up to such an argument, take such a stand, that I have no locus standi to question the service of the respondent number 3. But not only that, Your Ladyship, my ground in my writ petition is that the respondent number 3 has not been recruited in terms of the service rules. Therefore, the respondent number 3 has got no business being in the seniority list. He could not have been included in the seniority list at all. Let him continue in service. What way the state respondents want to keep, let them keep him. But in the service rule of the NIDC, in the service of the NIDC, he has got no business being included in the seniority list where my name appears. Since he has been appointed, the HORSE rules, the long length of service also offers him no protection. And even at this stage, his service is liable to be caution set aside. That is my case, Your Ladyship. He must be removed from the service of the NIDC. If the state respondents wish to retain his service cannot find place in the same seniority list with me. So that is my case, Your Ladyship. His service must go. Secondly, if the state respondents wish to retain his service, his name cannot find mention in the same seniority list as me. It is elsewhere. And that is up to them.
In your pleadings also?
Yes, it is there in my plea. It must be elsewhere, not here. Now, what does the private respondent say, Your Ladyship? The first few paragraphs deal with the service rules. There was 1, 2, 3, 4. Mainly about the service rules. And paragraph 5 is about my service. There's no need to get into that again, Your Leadership. Then paragraph 5, paragraph C, 5C at page 6. Paragraph C.
Page 6.
Page 6, bottom of the page, C. The respondent number 3 was initially appointed on a temporary basis to the post of assistant manager by the letter dated 1/4/2005.
Looking at
The affidavit of the respondent number 3.
affidavit in reply.
It's a thick affidavit, Your Ladyship. It's a thick affidavit. It'll be one of the other affidavits. Respondent number 3. The last one, maybe. Yes.
So many affidavits also.
Yes. At page 6.
C.
C, yes, Your Ladyship, at the bottom of the page. that the respondent was initially appointed on a temporary basis to the post of assistant manager by letter dated 1/4/2005. He joined on such and such extension orders, etc. Then extension orders. Then the next paragraph, page 7,
Yes.
the second paragraph. The NIDC, being a government of Nagaland undertaking, has adopted and decided to follow the policy of the decisions of the state government, service guidelines with regard to the service conditions of its employees, like the regular employees of the state government. The government of Nagaland, by office memorandum dated 4/8/2008, had formulated a regularization scheme for regularizations of contract ad hoc appointments against sanctioned posts where obtained 3 years of continuous. So this is the stand of the private respondent. He has been regularized in terms of the scheme.
That scheme.
Yes. Then page 8, the private respondent says that since his service was regularized in terms of the scheme, there is no illegality. All formalities prescribed by the scheme have been followed, so therefore there is no illegality. That is paragraph 8. Then at page 9. D, about redesignation of posts. We're not concerned with that. Then E is about my representations. And F, again, redesignation. And about the post restructuring in the department. Then G, other review committee. That's about procedures. Then H talks about the post of deputy manager and how it is to be filled up. This paragraph, may I read, Your Ladyship?
Yes.
That the deponent respectfully states that in view of the fact that the post of deputy manager is to be filled up by 50% by direct recruitment, and having learned that the corporation was on the process for direct recruitment, he had submitted an application dated 17/7/2012 to the MD for the post of deputy manager as a fresh candidate. His own statements now. Of course, this is in consonance with what he has written in his application. His application was accepted by the competent authority. Accordingly, a circular dated was directed to appear the examination to be held on 21/7/2012. A little misleading. Some facts have been concealed. Of course, it is there in my petition. He was directed to appear before a DPC. Accordingly, he appeared the examination as a fresh candidate, again, misleading statement, to the post of deputy manager. He was found successful and recommended for direct recruitment as manager, and which is clear from the minutes dated 26/7/2012. It clearly shows that respondent number 3 was appointed strictly in accordance with the service rules on the direct recruitment quota. Absolutely wrong. This is an absolutely wrong statement, Your Leadership. The DPC recommended him for direct recruitment. He was not appointed according to the service rules. Then the 185th meeting of the BOD and the approval of the petitioner's appointment, which we referred to earlier, Your Leadership. No need to go into that. Then the various promotions that both of us were allowed in the remaining paragraphs. Then paragraph 13, relation becomes paragraph 13. In the middle paragraph, that is respectfully stated. Page 13. Page 13, page 13. Yes, in the middle. That is respectfully stated that Rule 28 clearly provides that interstate seniority between direct recruits and departmental promotees appointed to the same day in a particular cadre shall be 40% and 60% respectively. Direct recruits being given precedence over departmental promotees when such a situation arises. It is humbly reiterated that the petitioner is a departmental promotee to the post of deputy manager legal who joined on 17/8/2012, whereas the respondent number 3 is a direct recruit to the post of deputy manager. Is it possible, Your Ladyship? Could the DPC have directly recruited the petitioner? No. The rule says for direct recruitment, the process is through the selection committee, not by the DPC. Then paragraph J is again about the approval by the board. and certain appointments in certain posts. Then K is about representation submitted, and where the petitioner, the respondent number 3 alleges that I have suppressed certain facts, not really true. And L, the cadre review committee, decisions of the cadre review committee, and ultimately, in the last paragraph, leadership, last 1, 2, 3, 4, 5, 6 line at page 15. The word
It was
it.
notified.
Yes, it was notified by notification dated 15/6/2017, and which was incorporated into service rules by the annexures and such. The post of deputy manager became a 100% promotional post with effect from 15/6/2017. So basically, by the 15/6/2017, all the posts which we are now talking about came into existence, and the so-called classifications came into existence. Not before this. Not before this. That everyone must admit. No one can deny that. Then the further promotions, LM, then N, then N, and O is again about the rules. O is again about the rules of the NIDC, Rule 28 and Rule 29. Then P at page 18, that the DPC was held on 10/3/23 and which was conducted in accordance with Rule 29. The DPC had recommended respondent number 3 and the writ petitioner to the post of general manager. Respondent number 3 as serial number 1 and the petitioner as serial number 2. In compliance with the recommendation of the DPC held on 10/3/23, the competent authority had issued the notification dated 15/3/2023. The competent authority had also issued a officiating promotion letter dated 15/3/23. The regularization of the officiating promotion shall be subject to the approval of the BOD. Also, the writ petitioner was given officiating promotion to the post of GM by letter dated 15/3/2023 on the same terms and conditions. It is respectfully stated that the pay scale of deputy GM is 79,900, pay level 16, and the scale pay of general manager is 1,02,000, pay level 17. It is also learned from reliable sources that the APR of the writ petitioner in the grade of DGM for the so he has the respondent number 3 has even got the ACRs. I don't know how. This is something which has not been made available to me. Then at paragraph Q. But your leadership will see in the minutes of the DPC, which was held on 10/3/23. Earlier we were referring to your leadership will recall.
Yes.
There is no mention of anything. There's just a bare recommendation of promotion to the various grades.
Thanks.
Yes. Then page 10, page 20, paragraph Q. Paragraph Q. The claim of the petitioner at the bottom of this, at the middle of this paragraph. It was done strictly in accordance with the service rule and the standing policy decision of the government and the norms, guidelines, directions laid down by the BOD and NIDC Limited from time to time, which is the competent authority as well as authorized by the memorandum and articles of association as well as the service rules. It is also humbly submitted that since the petitioner is a promotee in the rank of deputy manager, whereas the respondent number 3 is a direct recruit in the grade of deputy manager and appointed earlier than the writ petitioner, he is senior in the grade of deputy manager in terms of Rule 28 of the service rules. It is also reiterated that the promotion to the post of general manager, as per the DPC minutes dated 10/3/23, it was done strictly in accordance with Rule 29 of the service rules and the established guidelines and procedures. Now, Rule 29 is very clear, Your Ladyship. Seniority in the lower grades will still count. And seniority will be lost only in the case of supersession. Only in the case of supersession. Here, no one was superseded. Both of them were promoted on the same date. So this is the case of the private respondent. This is the case of the private respondent. Now, For this, if you may go through the rules again once more. The rules once more.
Yes.
Rule 7 at page 8. Appointments shall be made to one of the following: direct recruitment, promotion, deputation. No regularization. Regularization is alien to any rules. The office memorandum, I have enclosed it in my affidavit in reply, Your Ladyship. The office memorandums which, on the basis of which this one number 3 says that that has been quashed and set aside by the Supreme
That's
Court.
2008.
Yes, that has been quashed and set aside. It is there in my reply to this, to the affidavit of the respondent number 3. Then Rule 10, Leadership Rule 10. Direct appointment to the services of the corporation shall be made as follows. A, the post of officers through a service selection committee constituted for the purpose by the board. So in our case, DPCs for promotion, direct recruitment is by the service selection committee. And service selection committee must advertise the posts so that all eligible persons can apply. Here, by a process of subversion of the rules, the respondents 1 and 2 have allowed the respondent number 3 to be directly recruited through the DPC. That is something which is completely abhorrent to service jurisprudence. It cannot be countenanced, no matter what arguments the respondents collectively advance, Your Ladyship. Such an argument cannot be countenanced. Countenancing such an argument would be the death knell of the rule of law. Then Rule 28 and 29, again, Your Lordship, at page 15. Seniority of persons appointed to a grade shall be determined in the class of posts to which they are appointed by the date of joining a post. The inter-se seniority of persons promoted from a lower grade shall be maintained in the higher grade. Kindly note that, Your Ladyship. In the higher grade as well, except in the case of supersession. Except in the case of supersession. Inter-se seniority between direct recruits and department promotees appointed on the same day in a particular cadre post shall be 60% and 40% respectively. Direct recruitment being given precedence over departmental promotees when such situation arises. In case 2 or more persons appointed directly on the same day in the same class, category or grade, the seniority shall be determined by merit only. So if you can go to the first part of this Rule 28 again, Your Ladyship. Seniority of persons appointed to a grade shall be determined in the class of posts to which they are appointed by the date of joining the posts. The inter-se seniority of the persons promoted from a lower grade shall be maintained in a higher grade as well, except in the case of supersession. So in the case of supersession, when 2 persons are competing for the same post, the junior supersedes and the senior is left behind. That way the seniority is affected. When 2 persons are promoted to 2 different posts, 2 persons are appointed to 2 different posts. How can you say one supersedes the other, Your Ladyship? Supersession is basically about someone being offered promotion ahead of the junior. The junior being promoted in preference of the senior. So this is not a case of supersession. The case at hand is not a case of supersession. It's a case of 2 persons being appointed to 2 different posts. And therefore, seniority in the lower grades will prevail as stipulated in Rule 29. But even otherwise, Your Ladyship, Rule 28 to 9 has no application as far as the respondent number 3 is concerned. No application at all. And he cannot be considered for seniority in the service rules of the NIDC. Where he falls, that is up to the NIDC to decide. But he cannot be given the benefits of the service rules. He cannot be in the same service as me. He is someone who is alien to the rules. I think the facts are done. The arguments on law points are also done. Now, one more thing, in addition, one more argument which has been taken. The respondent number 3 has submitted and has preferred an additional argument saying that the minutes of the DPC of 10/3/2023 have not been challenged. Is it necessary, Your Leadership? The law is clear on this point. I finally replied to that. Initially, in the first writ petition, the minutes of the Board of Directors was not challenged. So I, as a matter of abundant caution, I amended the petition. After I filed the amended petition, now the respondent number 3 took up the argument that the minutes of the DPC of 2023 were not challenged. I have filed a reply to this. I have said it's not necessary to challenge the minutes of the DPC. It is recommendatory in nature. Once it translates into a notification issued by the government, then I am agreed. I have challenged the notification. And another ground which, after the amended petition, another ground which the respondent number 3 has taken is that the circular by which he was asked to appear for an interview before the DPC, that has not been challenged. Is that necessary, Your Leadership? Respondent number 3 has filed these 2 objections after the amended petition, that I have not challenged the circular by which he was asked to present himself before the DPC, and I have not challenged the minutes of the DPC of 2023. Not necessary, Your Leadership. Leadership, I'll go to the list of authorities right now.
Yes.
I have culled out the principles, Your Leadership. We're all familiar with the principles, so to save time, I've culled out the principles. The first is appointment. This is 2006 for SSC 1, Homa Devi, paragraphs 43 and 54.
I think
may not be necessary.
may not be necessary. Just keep it here and then read later.
So the first bullet point, Your Leadership, unless the appointment is in terms of the relevant rules and after a proper competition among qualified persons, the same would not confer any right on the appointee. All judgment and orders contrary to the directions issued shall be denuded of their status as precedents. If judgments and orders can be denuded, Your Leadership, circulars and guidelines issued by the government, they stand on a much less footing. So the fact that the notification of 2008 was challenged and then set aside later at the point of time is of no relevance. The point is, the law laid down by the Supreme Court is binding, and the circular of 2008 could not have been resorted to.
1 minute. Sorry,
Yes,
just
yes.
one line. If the division bench of the judgment, if the division bench of this honorable court, by which the circular of 2008, the policy was interfered. But the division bench of this honorable court make it very clear that the past appointments should be fixed.
No.
I was satisfied.
In that order, in that judgment.
Yes, because henceforth, at the direction that henceforth, no further appointment through the policy regularization, but any appointment made till then were not interfered. Because I was a counsel in that case.
Okay, we'll see.
Again, but you have to take that, Your Leadership, that will have to be taken in the context of the law laid down by the Supreme Court. Then 2006, 5 SCC, and paragraphs 2, 3, 8, 16, 18, 20, 22. The first bullet point, state within the meaning of Article 12 of the Constitution is bound to comply with the constitutional requirements as mandated in Articles 14 and 16 thereof. Regularization is not a mode of appointment. Appointment without following rules are a nullity. The state does not enjoy the power to make appointments through executive actions. Appointments made on the basis of applications submitted are illegal. Recruitment rules ignored and selection committee not properly constituted point to illegality in the appointments. Long years of service, no protection. Then 3, management, the 2008-11 SSC 278. When a statutory action is performed, it must be done in a manner laid down under the statute or not at all. All actions of statutory authorities must be confined within the 4 corners of the statute. Violation thereof would be a nullity in making recruitments if the equality clauses contained in Articles 14 and 16 are not complied with. No benefits can be derived therefrom. Then 2006, 2 SSC 482. Any regular appointment to a post under the state without issuing an advertisement and issuing applications should be inviting applications, Your Ladyship, from eligible candidates, and without holding a proper selection where all eligible candidates get a fair chance to compete, violates the guarantee enshrined under Article 16 of the Constitution. 2005, 12 SCC, long years of service is no protection for an appointment made in violation of the rules. Seniority, 2008 Supplementary GLT 676. This is a division bench case, Your Lordship, and this is from our own bench. After the decision of the Constitution Bench in Secretary State of Karnataka versus Uma Devi, the sustainability or otherwise of public employment has to be viewed in the light of the constitutional scheme of public employment. Appointments can be made only in accordance with the recruitment rules. No order, notification, or circular can be substituted for statutory law. It is the bounden duty of the court to ensure that the beneficiary of an illegal appointment or an illegal promotion does not steal a march over the regular appointee. An irregular appointee cannot be placed senior to a regular employee. Then 2008 1 GLT 769. Persons regularized in service cannot be placed above persons appointed in accordance with the statutory rules. Then 2008 15 SEC 332. Regularized appointees should be in a separate seniority list and they cannot steal a march over the regular appointees. Regularized appointees cannot occupy the post of regular appointees either at entry level or higher level. So in this case, the Supreme Court is very clear. You have to have a separate list for them. And they cannot occupy the posts meant for regular employees, whether at the entry level or at the higher level. Then 4, 2023, 3 GLT 786. Persons regularized in service belong to a different stream and they cannot claim seniority over the candidates appointed through the selection process. Persons appointed in breach of rules form a separate class. This is our own High Court, Your Ladyship. Principles on exercise of authority. An order passed by the statutory authority must be judged on the basis of the contents thereof and not as explained in the affidavit. The validity, next is 2024 5 SEC 306. The validity of the order impugned has to be tested on the basis of the reasoning contained therein, and that the authorities are not supposed to supplement the same by means of extraneous material or affidavit before the courts. 3, this is about the recommendations of the DPC, which I was referring to earlier, Your Ladyship. Recommendations of the DPC are advisory in nature and not binding on the authority. Now, if you can step back to the earlier page, this seniority at B, seniority at 1 and 2, the authorities in serial 1 and 2. Both these decisions rely on a Supreme Court case, Your Ladyship. And in this case, the Supreme Court says that if someone has been appointed illegally, ultra vires rules, without interfering with his appointment order, the seniority can be corrected. Those appointed on a regular basis will be placed senior and he will rank below that. I'm not going through the entire text, but this is just for your ladyship's information. I am sure your ladyship is aware of this principle also.
You provide the judgments later if you can get photocopies.
Everything is here, your ladyship. All the books are here. Okay. So 1 and 2, both of these rely on the decision of the Supreme Court, where Supreme Court says it is not, if someone's appointment may be illegal.
2 GLTs.
Yes. Someone's appointment may be illegal, but without interfering with his appointment order, we can issue directions that those who have been affected by him, their position is not adversely affected, and his position also can be protected by placing him below them in the seniority list. Then there is another decision now in addition. This is by a division bench of this honorable court.
This is on what principle?
This is on the principle. I am taking the other case. The first limb of my argument, Your Ladyship, is that the appointment must go. There is no protection. If at all, relying on the
If at
Supreme
all,
Court decision, if the Supreme Court comes to the conclusion that it may not be necessary to quash and set aside the orders, but orders to protect the interests of the petitioner. In that case, the rules will apply, and the rule says the seniority in the lower position will prevail. In that case, I am senior. The second principle is, Your Ladyship, if two persons are appointed on the same day, promoted by the same order, then the elder among them will be senior. The elder among them will be senior. So this is the decision of this Honorable Court in the division bench in our own Nagaland context, Your Ladyship. Can we start from paragraph 19, Your Ladyship?
The observation.
Yes, the observation made by the Department of Personnel and Administrative Reforms in the letter dated 6/12/12, and which is reproduced at para 20 of the affidavit of opposition filed by the state respondents, does not indicate that the draft rule of 2011 was being considered when it decided to treat the petitioner as senior to the appellant as senior to respondent one. Further, there is no indication in the absorption orders of the parties that the absorption had been made on the basis of the draft rules of 2011. The state respondents and the affidavit of opposition have for the first time stated that the draft rules of 2011 were followed. In the case of MS Gill, the apex court has held that the validity of an order must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of an affidavit or otherwise. Otherwise, a bad order may get validated by additional grounds later brought on. With regard to the appellant's submission that the appellant was earlier working in an equivalent grade as Deputy Director DUDA, a perusal of the notification dated 13/4/2008 shows that the appellant was deputed to the post of Deputy Director in a scale pay of such and such. The same does not show that the scale of pay of the appellant is the same scale of pay of Deputy Director and Deputation, though an absorption of the appellant had been absorbed into the post of Deputy Director in the pay of rupees such and such. In the case of such and such, 2011 8 SEC, the apex court has held at para 18, 19, 26, and 27 as follows. The law is clear that seniority is an incidence of service, and where the service rules prescribe that the method of its computation is squarely governed by such rules. In the absence of provision, ordinarily in the length of service is taken into account. The Supreme Court in such and such has laid down that it is a well-settled principle of service jurisprudence that in the absence of any specific rule, the seniority amongst persons holding similar posts in the same cadre has to be determined on the basis of the length of service and not any fortuitous circumstances. Determining seniority is a vital aspect in the service career of an employee. If future promotion is dependent on this, therefore the determination of seniority must be based on some principles which are just and fair. This is the mandate of Articles 14 and 16. The reliance by the respondents on the judgment of this court in B. Permanent, etc., in the facts is misconceived in the facts of the case. In that case, the court was dealing with Rule 27C of the Kerala State and Subordinate Services rules. In the instant case, there is no rule. Therefore, in this case, this court has to evoke a fair and just basis of seniority on the basis of the office memorandum discussed here above. For the reasons aforementioned, this court holds that for the determination of seniority of the officers who are recommended on the same date, age is the only valid and fair basis. As such, their seniority should be decided on the basis of age of the candidates who have been recommended for persons who are appointed on the same date. Even otherwise, the rules say, Your Ladyship, that seniority in the lower grades will prevail.
Lower grades.
Your Ladyship, I've tried not to take too much time. I think that is my case.
It's okay. In fact, you have shortened it.
Yes, I have indeed. So may I rest for a moment?
Okay. Should we start or?
Better in the, we submit together so that we can make it part of it. So on the next day.
Okay, let's continue then. keep it part third and list it on
Second or third?
second.
Yes.
Okay, 2nd June.
Third.
Second or third? Third. Second is Monday.
Okay, okay. Second is fine.
Second.
Yes. I have many others fixed on third.
That's it.
I have other cases fixed on third. Hmm? Okay.
It's okay. You just write part third. Tell them to write part third. List on third.
Yes.
Yes.
Second relation.
Oh, second June.
Yeah, 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 keep that.